from sections 9 to section 15, we can figure out, we can actually look at what, we can use it as a guidelines to figure out what procedure has to be followed and put it in our checklist as our incident report. Further, there are POSH rules, rules 6 to 9. We have to follow that and figure out the incident report. So basically sections 9 to 15 and rules 6 to 9. So let's have a look at the sections first. Okay, so the first is complaint of sexual harassment. So whether it is in writing, you were correct, aggrieved women may make in writing a complaint, so we've added that. Then within a period of 3 months, that also we've added. Or if when there are multiple incidents, then within a period of 3 months from the date of last incident. So this we've added. Now moving on, reasonable assistance to the woman, whether she was not able to provide the complaint in writing, then whether reasonable assistance given to the woman or not, that is one. Then whether the lady was prevented from filing a complaint within the set period under genuine circumstances. So in that case, whether extension of time limit of exceeding 3 months given or not. So we can see that from here. So how I'm approaching the sections now for today's class is not going through this entire section, but figuring out what we can take away from these sections for creating our checklist. Okay. Now this is about incapacity. We had discussed this while our exercise also. Physical or mental incapacity, her legal heir or such other person, or death or otherwise, her legal heir or such other person as may be prescribed may make a complaint under this section. Now if you go to the rules, it further clarifies who is the exact person who will be filing the complaint. So rule 6, complaint of sexual harassment, when there is physical incapacity, then in that case it's relative or friend, co-worker, officer of NCW or State Women's Commission, or any person who has knowledge of the incident with the written consent of the aggrieved woman. Similarly, it's given for mental incapacity also, where people like special educator, qualified psychiatrist, these people are also added. Now, then any third point is given where aggrieved woman for any other reason is unable to make complaint, then any person having knowledge of the incident with her written consent can make it. So that is also there. Then where she is dead, then with the consent of the legal heir, any person who has knowledge of the incident. So this is your guidelines that have to be followed. So we can just say that whether the person whether in case the woman is incapacitated mentally or physically or dead, then whether the person filing the complaint is the correct authorized person or not. Okay, coming back to our provisions, conciliation. We had discussed conciliation as well. So, however, conciliation can only happen when the woman had requested for it. All right. So after the conciliation request has been made, whether steps taken by the inquiry committee, by the internal complaints committee have been taken or not. Okay, so conciliation may we can put that. This is about settlement. Whether whether copies of the settlement as recorded under subsection 2. So you have to provide, when a settlement is reached, copies have to be provided. So whether those copies have been provided or not. Then section 11 is about inquiry into the complaint. So here they are talking about different types of employment that can be undertaken with the organization. So one is the service rules will apply on you. Second, service rules don't apply on you. Then the inquiry has to be made according to the prescribed rules. So whether that has been done, or like I had discussed before while we were seeing the example, if in case of a domestic worker, local committee shall, if prima facie case exists, forward the complaint to the police within a period of 7 days for registering the case under section 509 of the IPC, outraging the modesty of a woman. So if the service rules are applying, then the service rule procedure has to be followed. If they are not applicable, then the rules as may be prescribed, or in case of domestic workers, it has to be forwarded to the police within 7 days, and only if prima facie existence of the case is there. Now, the settlement that was reached in section 10(2), if we have to another proviso to section 11 is that whether all the conditions of the settlement are being followed by the respondent or not. If not, then the inquiry can again commence. Can commence from the very beginning, because obviously they have broken the conditions of the settlement. Yes, and like Simran said, the opportunity of being heard and a copy of the findings shall be made available to both the parties, enabling them to make representations against the findings before the committee. This one is not relevant. It's just a substantive thing. Okay. Now, interim measures, like Rituparna very correctly pointed out, action taken during pendency of inquiry. This section 12. So, whether a case exists, if a woman requests, whether a case exists for her to seek transfer for herself or for the respondent to any other workplace, or whether a case exists for granting her leave for a period up to 3 months, or any other relief that she may be prescribed. And 2 is again substantive. Yes, whether the employer has implemented the recommendations of the interim measures and sent a copy to the internal complaints committee or local committee or not. So the implementation part is also could be a part of the checklist. Then inquiry report. So the period of inquiry report is given that after a period of 10 days from the date of completion of inquiry, the report has to be provided and it has to be made available to the concerned party. So whether this period of 10 days is followed or not.